this legislation seems to further widen the definition of what is a religious body, way beyond what was defined, as you say, like, you know, charity groups and so on are religious organisations, without furthering our understanding of what is a religion. So, what's to stop me as a white Australian forming a group that wants to prevent mosques being built around the country, for example, because I'm a patriotic Australian, then formulating that around a religion and saying my beliefs as a white racist is that that's part of my religion, therefore I can say anything I like against Muslims.
Let me respond to that, and then I'll take the others. The case you're referring to, as you probably know, is the 1983 Church of the New Faith case, the so-called Scientology case. Just to bring you into that, what happened was the Church of the New Faith, the Scientologists, wanted to be taxed as a religion. In other words, not to pay much tax. As you know, as I mentioned before, religions don't pay much tax. In fact, they get charitable status, tax deductions. And people were saying, sorry, but you're not really a religion, you're just Scientologists. And the High Court came down in favour of the Scientologists, saying, well, actually, we're not going to have to think about Anglicanism or Catholicism. If you've got a belief, I've got the definition in front of me now, but essentially a belief in a thing or a concept or an abstract, so long as it's clearly articulated and set down in articulation terms, you can be religion. So that was actually a very broadening of it, and it's one of the reasons why I think, well, I certainly agree with both of the positions that we've talked about so far, that bringing in something about religious freedom raised that whole question about whether or not something is or is not religious, hence going back to Peter's salient point and saying, wouldn't it be far better, rather than trying to couch this in this rather vague, amorphous idea of religions, does that include schools, does that include aged cares, does that include etc., etc., to talk about human rights, to talk about some sort of charter of rights. As you may know, we're the only OECD country that doesn't have a charter of rights. So I agree with you insofar as tossing religion into the mix, even to pick up David's point and say let's treat it as, for example, the 1975 Race Discrimination Act, would suffer the same difficulties you've highlighted, that the term religious itself is very difficult to define.
So there's nothing to stop me doing it.
My guess would be, I can't test the Christian Porter draft bill in relation to that, but it'd be close to saying, so long as you had formed sufficient number of people, you had a belief in something, a concept, an idea, which was clearly capable of articulation, and you set that down in a precept, a la the Scientologists, you could present that. Now mind you, you'd run into a difficulty if it had the effect of discriminating against Muslims on the basis of your racist beliefs. So I think the bill would have something there to capture that. But that absent your argument, the idea of tossing into the mix a very vague definition of religion, and in fact it's the definition of religion that emerges in the census. You know, when you're asked whether or not you have a religion, the Scientology case definition is the one that's now used in relation to ticking the box as to whether or not you have or have not a religion. That's exactly the same definition coming out of the High Court.
There is a little known religion which is really true. So my surname's Sanderman. There is a religion called Sandermania, which are long lost, and it actually relates to the Shaker, not the Quakers, but the Shakers.
Yes.
And so, you know, what is a religion and what is a religious belief is a many splendid thing. And I agree with Rick. Once that genie is let out of the bag, there's going to be some big advantage in being considered a religion.
Which is exactly the point, isn't it, really? I think this could go anywhere.
It will.
Just a comment, there are modern religions that behave much more like businesses, and I would say Scientology is one because they sell all their courses. You can't be a Scientologist without being audited and without buying a series of lessons and so on. I was a member of the Rigpa Buddhist Association for a while until I saw the light and realised that that's what they were doing. They were selling courses, and the leader of it was actually found guilty in court of abuse and financial misdoings. And another group that I think act more like a business than a religion are indeed Hillsong. It's a massive business. They pay, you get a great income if you're a musician or that sort of thing. So I think this business of getting rid of religion as the thing that we're legislating for or against is a really good idea, because it does besmirch existing traditional religions like Hinduism, Islam, Christianity, etc. When you have these Johnny-come-lately, basically, well, they're profiteers, claiming to be a religion. It sort of drags us all down.
It's assigning religious freedom not to people, but to organisations.
That's it, yes.
That's what this bill does.
Not just
And that
that,
is-
but to an activity of an organisation.
But it's that step that says religious freedom is about institutions and organisations, not about religious freedom for individuals, but organisations have that characteristic as well, and that's very dangerous, I believe.
Lily, you have a question?
Yes, I'm thinking of where would we want to be 50 years from now. At the moment, we have very much the sort of the Christian tradition is in power. But what would be our inclusive dream for more religions to come together and in a human rights charter work with where we want to be? I'm quite interested in the fact that you talk about the numbers of the Quakers, and how does that then feel, maybe towards the Muslims, that, do you feel out, and where would you like to be in 50 years?
All right, I might start answering that. I'm probably one of the youngest Quakers in South Australia, and I'm quite one of the two. In 50 years' time, I suspect we'll be a very small number. We don't proselytise. Our belief is that people will find Quakers, and it seems that fewer people are. So we may not exist at all. In fact, 12 years ago, before I was a Quaker, I thought Quakers had died out. So I hope that's not our future, because we've done some amazing things. We certainly have made significant social change. But I think engaging with other well-intentioned people, I know important now, it doesn't need, but like as I said about Quakers ourselves, we don't require that someone believes in a specific God. So broadening that out, I think, will help. I think merging is probably what's going to happen.
I'd still like to be around in 50 years' time. That's number one.
Oh,
So
you might be.
we probably won't be,
You might be.
that's by then our medical science will elongate. That's my faith position. I think it means interfaith is going to be much more important than it is now. So instead of a little group of people here, I hope the relationship between different beliefs is actually healthy, that Australia doesn't follow the history of other countries where religious conflict turns into something much nastier and gets associated with politics and things like that. So having a concept of interfaith, I think I would hope that actually grows and strengthens. In terms of religious belief, I hope that religion is still around in 50 years' time, and the kind of aggressive secularist approach which tries to drive out all religion is bad, that belief I think is the greatest threat. So religion is under threat in Australia because of that kind of sense that, well, all religion's superstition and bad. And that's quite a powerful and growing sense in the community. Now, I think it's unthinking. I think it's because, to some extent, some religious organisations, like some of the established churches, are cowed by the sex abuse history that Rick talked about. But I think in the face of that somehow this identity, for this identity to emerge, we have to lose this identity. I think that's what we're finding at the moment. And religion is perhaps a little, in some areas, not so much overall, but in some areas, is in retreat. And I think in 50 years it would be great if we did have a vibrant multi-faith community.
Let me answer very quickly, Lily, to say that, as most of you would know, the census we had in 2016 published the view that 30% of Australians now declare no religion. It's only the second time they've asked that question, and down significantly over the last 60 years, obviously. The Christian religion still represents 50% of Australians, ticking that box. So 50% of respondents still ticked a box that said they had some affiliation with the Christian religion. So it's half of Australians that are over 18 ticking that particular box, but it's massively in decline. I'll make a statement and say that I think what's happening in relation to the Christian Quarter bills, which are now still going through another round of iterations, is in some way shoring up the more conservative Christian voices to say, we don't want to be dead and gone in 50 years. This is the only way we can do it, by shoring this up and making sure that we are free to express how we are, that we can proselytise, that we're not going to be in any way further abashed by the secularists. I think that's a wrong strategy. I want to come back to this point again that both of my brethren have made today, that a far better strategy in order to preserve the multi-faith, the beautiful multi-quilt faith community that we have in Australia, the best way to preserve that would be to abandon this idea of trying to suggest that we can have a religion freedom bill or something rather, which really is just trying to shore up some fairly homophobic views, and come back to a charter of rights that actually said, as Peter said before, this is what freedom of speech is about, this is what freedom of life is about, this is how we order ourselves in society, and let those multi-faith organisations merge into that particular legislation. That's how I would do it. I really think in some respects the so-called freedom of religion and belief legislation is actually doing exactly the opposite.
That is the problem, really, that some conservative religious groups don't really believe in those rights.
In the more broad rights of freedom of speech, and freedom of assembly that Peter was talking about.
Yeah.
Can we open up? Does anybody else have a question that they would like to ask?
I'm just wondering what the passing of that bill, how that would relate to Israel-Folau kind of statements. Because I think there is an Israel-Folau clause in it, isn't it?
Sort of, yes. In fact, it's funny you should say that, because I just happened to bring along a little piece that was prepared by the academics calling themselves the Australian Discrimination Law Experts Group. And just going back, refreshing those of you who didn't follow the Israel-Folau, Israel-Folau has a fairly conservative view of a somewhat warped statement found in a Corinthian letter somewhere that essentially says that, in fact, a whole range of people, including fornicators and other people, liars. I'm in real trouble. Most of us here, yes, are all going to go to hell. Assuming whatever this concept of hell is. My own mother used to say hell was sitting around a room like this doing Christian action songs. 24 hours a day, that would be her definition of hell. But leaving aside that rather ridiculous view, does it allow the Falaus to make those sorts of statements regularly? And I think the legislation, as I said, in relation to Porteous and Falau, it would free up that level of statement. Now again, if we were to embody that into some freedom of speech charter, there'd be a whole range of caveats and cautions that would be having people free from sort of slurs like that, homophobic slurs, etc. But here's what the experts group said. Under the current, well, the pre-February version of the legislation, mind you, can you imagine trying to put this legislation together to please everyone? The fact is no one likes it. And in fact, I have a complete doubt that it'll ever pass. If it does come back, you've got a Senate that's got crossbenchers. They're not going to pass it anyway. So the whole thing really is flying in the face of absurdity. But here's what they said. Here's 4 examples of what the experts group on the previous Christian Porter legislation would allow. An employer telling a transgender employee their identity is against the laws of God. A childcare provider saying to a single mother she is evil for depriving her child of a father. A teacher telling a student with a disability that his or her disability is a trial imposed by God. And a waiter in a cafe saying to a gay couple, I'll pray for your sins. So they're suggesting, Falau-like, that the new legislation does allow more bigotry because those statements will be more protected. Again, to use the phrase read by David before, the legislation is not a sword. It's not actually saying it's a right to have religious freedom. It's actually allowing or pulling back on the limitations of what previously had been suppressed by the anti-discrimination legislation, freeing that up to allow more bigoted statements to be made in the name of religious freedom, and I worry about that.
But doesn't it also mean that employers, say the rugby league, are not allowed to have a clause in their employment arrangements preventing people from saying such things?
It may do just that, and you're quite right in saying that was the big issue in relation to the Folau case, that there was a restraint of trade. It was a bit more complicated insofar as he had signed a restraint clause saying he wouldn't say those things, and there's a commercial part of the law that says you can't impose upon people such restraints that they can't earn their livelihood. All of our commercial law is about people being able to earn the maximum amount of money in their livelihood. So he was saying, hey, my livelihood's now been threatened when all I was doing was quoting the scriptures. So in fact, he was always going to win. He was always going to win, because in that respect, the restraint placed upon him by that clause was an unreasonable one, because it meant he couldn't now be employed by Rugby Australia. Mind you, he was playing in Europe now anyway, so it's neither here nor there. But you're quite right. It would put a complete constraint on employers from maintaining some degree of decorum in the way in which they were conducting their affairs.
Unless you were a religious employer, in which case you could actually, through your doctrinal statement, put all sorts of conditions on you. And one of the things that's happening with some of the churches interstate to our east is that they are enlarging their doctrinal statements from the traditional orthodoxy to encompass a whole lot of statements around particular social activities, so we can ban that from our facilities.
So when the legislation comes in, they've got those doctrinally...
They've got them in place. So I suppose I'm an old-fashioned liberal, I suppose, in the sense that I actually would like to see a bit of freedom of speech. I think freedom of speech, even to the point of offending others, as long as I don't vilify people, this is where it gets controversial, is really important. So there is the contest of ideas. So I can advance my religion as long as I'm not vilifying other people. That is, so at the moment, if we took the Racial Discrimination Act, I couldn't offend you as well as I couldn't vilify you. This is where Rick and I may disagree, I'm not sure. But it is a point of how much you value freedom of speech versus the kind of, well, you can't offend me because I don't like what you've said, whether it's religious or not religious. So it's a really tricky area in our community at the moment, where groups want to make sure that they are not attacked or they are not criticised. The problem with the racial discrimination area at the moment is it's not a test of whether a reasonable person think that's offensive, it's whether I think it's offensive. And of course I always will.
Before Anne comes in, can I just put a little legal element to that? What Peter's talking about is Section 18C of the Race Discrimination Act, which came in 1985, again as a complete sleeper. A complete sleeper. 18C basically said you are free to speak about things unless and until you humiliate, vilify or offend another person, in which case the Racial Discrimination Act then stomped on you. No one looked even for a second at it until Andrew Bolt came along and made some statements about fair-skinned Aborigines, and they took an action against him, and they're basically that he had vilified them. 18C came up into the highlight. The courts upheld the complaint against Bolt. He went ballistic in relation to it, got George Brandis on side. George Brandis said, wait a minute, everyone has the right to be a bigot, but we've still got 18C. I actually think 18C does go a little too far. That's probably where Peter and I disagree. Anne, sorry.
No, we agree, you said. I think we kind of almost agree.
Almost.
Sort of kind of.
I'd take away offend.
Yeah.
Do we agree on that?
Yes, we
Okay,
do.
we agree on that.
And then we're in complete agreement. But the legal test is usually Now, I'm not a lawyer, so Rick can actually correct me here. Please do. The usual test of anything like that is what does the mythical reasonable person think? But in that particular way, the courts have actually interpreted it not that it's reasonable to take offence to that statement, but in fact, I get to choose as to whether I'm offended. And as the subject of that comment, of course, I'm always going to be offended. So it's a law that really inhibits freedom of speech, and as such, it inhibits freedom of religion, because you can't actually then necessarily say the precepts of your religion, like the Archbishop in Tasmania. You can be quoting chapter and verse of your sacred text and be in trouble. Now, Israel Folau didn't quote the sacred text. It was a mistranslation, a paraphrase that was awful. And he's not well, it's very funny to me that the people defending Israel Folau's freedom there didn't realise that Israel Folau belongs to a very funny little sect run by his father, which has some very funny beliefs. They don't believe in the Trinity, for a start.
But defended by the Scientology case.
Yeah.
Yes, I think you've sort of already started asking it, because I was thinking when hearing conversations about this, about someone so extreme such as the Ku Klux Klan, that actually do have wider community support. They have the power. They are a voice where people go, oh no, I'm not upset by what they're doing. So I call them funny money churches or funny money religions. You know, there's whole groups of people that are now actually being able to use things like their professionalism and to become, you know, and use business sense to actually grow their power. And in this situation then, with you were saying that there are other laws that could inhibit that discriminatory behaviour, such as, you know, horrible, back in the early Ku Klux Klan era, I suppose, in the 30s and 40s and 50s, when it was pretty disgusting, still is, and it still has that power, still can get away with it, because they weren't actually murdering, or they weren't doing, you know, if they actually caught doing the murder, they'd be caught, but if they were, their discrimination and they're basically
They do more than discriminate though, they vilify. So this is where words like vilify is really important.
Right.
Because if you vilify people, or you incite hatred or violence, even though you're not committing the violence yourself, you're asking other people to commit violence, then you're breaking the law. So that's a really important distinction. You're not just being offensive, you're actually vilifying or inciting hatred. That is the difference. And of course, some of the hard edges of religions can vilify and incite hatred against people from other religions. And that's where it gets very difficult, and we need to be strong. But that's not freedom of speech, that's inciting hatred.
And I think that's the thing of the wedge, isn't it? Because what's being discussed in Parliament, and what are they actually saying, and what's actually going to be written down, and we don't really hear or see that until after things are actually put in place. So that's some of the reflections that I know colleagues of mine have been actually talking about. Where are the boundaries? What is the elasticity on what is being used as their descriptors? You know.
Well, I think we've raised some issues for all of us to go home and think about. I'm somewhat heartened, Rick, that you feel that it might not get up anyway from internal problems, jumping hurdles within Parliament. But as members of the public, what should we be looking out for in terms of opportunities to provide feedback? And what would be the sense? I think community response is always better if people speak with their own views and their own thoughts, in their own words. But it's always very helpful, I think, to have a conversation like this that puts us across a broader array of ways to understand it or respond to what's being put up. But I guess I'm just, feeling for next steps and timeframes if you're aware of what they are.
Well, let each of us make a quick little response to that, because I think it's an excellent way to finish off. there have been a number of people who have suggested that the bills be split into the easy stuff and the hard stuff. And in fact, the essential questions typically around the ability of schools, as Peter highlighted, to purportedly, or religious schools purportedly, to have some discrimination against homosexuals is one of the tough questions. In fact, it's the tough question, and the Australian Law Reform Commission has been tasked to look at that to get that exactly right. In the meantime, so put that to one side. In the meantime, there's a whole bunch of actually easy stuff. I haven't got them listed here, but there's about 10 little items of tidying up stuff which at the moment is in a state of confusion, and I'm sure every one of us here would actually agree with, oh yes, that makes sense. Oh, I can see why it's a misunderstanding. Let's do this, this. There's a whole bunch of stuff like that that's in the legislation. Then there's the stuff we're talking about, the more freedom of speech, the ability to actually pronounce what it is that you believe about things and not be hauled before the Anti-Discrimination Board on the basis of vilifying or in some way offending another person. That's the stuff we've been talking about today. Then there's the hardline stuff, essentially about what it is that schools can and can't do with their students and their staff members, particularly in relation to homosexuals, which has gone off to the ARC. What I think we could be doing profitably would be to say, let's split the bills and make sure that the really good stuff gets dealt with straight away and the hard stuff is put off for another discussion, or in fact sent all off to the ARC, the Law Reform Commission. So if we finally do have some legislation, it's actually got some pretty good stuff behind it, and we don't have that situation where we pass some legislation and say, oh my goodness, look what this is allowed. So if I were to challenge you to advocate for, would be to split the bills, to get the easy stuff out of the way and the more difficult stuff put off for another couple of years while we work through it, rather than jump to conclusions to allow the sorts of fallow statements to be made more easily.
From my perspective, I am in disagreement, I have to say. It's a long Quaker tradition that if you don't have unity on a concept, then you defer the decision until you do have unity on it. And I appreciate on a national basis that's very hard to achieve. My concern with splitting the bills is that we will get the current government saying we've got this legislation through, even though it's only in part. And that's really mostly what Joe Public will see, and I think it's gone. So no, I disagree with you.
In the spirit of agreement and disagreement,
Very
and I got married in the Quaker meeting house, so I'm familiar with long meetings and discussion and trying to achieve consensus. You can, but it takes a long time. I would probably err on the side of Rick here. I think there are matters that are important to get through. One is, it's pretty important that churches, mosques, temples, synagogues be allowed to employ people of their own faith. And that is absolutely got to be clear. So the split I would like to see is between what I would regard as true religious organisations and these businesses like Anglicare, which have been set up alongside churches that actually receive large amounts of government money, provide services to people of all religious belief and none, and should not be allowed to discriminate in any way. And that's an important split. So yes, all sorts of rights for religious churches and mosques, temples, etc., to be able to discriminate around their belief systems, to employ their own people and to have a coherent belief system. It's very important, and to be able to project that belief system. But that doesn't apply to hospitals, and I don't believe schools either. Schools are a difficult case, but certainly it doesn't apply to organisations like Anglicare. We don't want to have that power to discriminate. We don't want to be considered to be religious organisations.
Thank you.
Thank you.